It was there because even as on the date of the impugned order, there were 7 state governments directly distributing electricity in their states. I don't mean through electricity board, Melots. Like West Bengal had a board, Karnataka had Karnataka Electricity Board, Delhi had Delhi Vidyut Board. Boards are separate entities. They had Melots perpetual succession common seal. Please come to the impugned order and please see Melots page number 181. And please, Melots, see what the appellate tribunal, Melots, in the civil appeal, Melots paper book, your lordships will find it in 181. At the bottom quadrant of 181, Melots, your lordships will find starting from the state of Arunachal Pradesh. Yes. Let's permit me to read just 5 lines. Let's please see there, Melots, state Arunachal Pradesh, Department of Power, function is generation, transmission, distribution. Please see Goa, Melots, Electricity Department, Goa, transmission and distribution. Jammu Kashmir, Power Development Department. Manipur, Electricity Department. Mizoram, Nagaland, Sikkim, Melots, Energy and Power Department, Electricity Department. So apart to the boards that existed and apart to Melots, I stand Melots for the Orissa discoms. Today Melots are privatized. There is a joint venture between Tata and Melots, the Orissa government, in terms of Orissa North Power, South Power distribution. We are private companies, so to speak. But as on the date when the APTEL was considering the import of the third proviso, which says when a government, appropriate government is involved in the distribution of electricity, the fact is that legislation covered the states which even today continue, Melots, as departments distributing electricity. In that light, Melots, it was not contemplated to say that instrumentality of the government, however it may be, railways, Melots, DMRC, for example, Delhi Metro, made an application, Melots, for a distribution license, indicating that we are large, we have capital adequacy, we need enormous power, make us a distribution licensee. Delhi has, Melots, BSES Yamuna, BSES Rajdhani, which are joint venture with Reliance, and it has Tata Power Distribution, which is a joint venture with Tata. Melots, in addition to it, DMRC wanted a distribution license. The commission said no, the appellate tribunal said no, you will not get a deemed distribution licensee. Forget alone that you will not even get a distribution licensee because we don't think you have an area of supply and you don't have capital adequacy. There also, Melots, rail, of course, may not be covered under the Railways Act. Therefore, Melots, if the intention is that any activity which the government may directly undertake or, Melots, indirectly through an instrumentality undertake, and because there is enormous power which is consumed, and I'll come to public interest, and of course there is public interest that railway tickets must, of course, be at a lower par. Does not mean, Melots, that they undertake distribution. Why? Because the previous argument to say there is no supply. Supply means sale. Sale must be to a third-party consumer. It can't be to somebody who is related to me otherwise. For that issue, Melots, on dual relationship, kindly see, Melots, in the convenience compilation. Please see page number 147. Please see who the power goes to from railways other than to its own railway engines. That's 147. I'll of course only commend, Melots. Your lordships have seen Sessa Sterlite repeatedly. Paragraph 38 says, even if you are a distribution licensee, but if you take power and consume power for yourself, you have to pay cross subsidy. For example, Melots, I'll take my own illustration. I am Tata Power Distribution. Melots, when I am TPSODL in Orissa, I, Melots, of course, buy bulk power from Melots, the entity called Gridco in Orissa. Now, if I consume that power in my offices, I pay, Melots, the tariff for it, which includes the cross subsidy component. Please see 147, Melots. Melots, this is the bilateral agreement. I'm sorry. Melots, it starts at 146. Please see 147, Melots. Bilateral agreement formed for temporary electrical connection with contractor. I'll just read, Melots, 3 conditions. Terms and conditions for temporary connection. 1. Electricity connection shall be given at railways nearest distribution board / substation as feasible. Please see 3. Party shall agree to pay energy consumption charge as well as service connection charge at the rate fixed by railway. Distribution licensee has no power to fix its rate. The rate is fixed, Melots, by the commission. 5. The supply so given shall be utilized only in connection with the particular contract awarded by the railways. It may be a canteen, it may be a hospital, it may be, Melots, a construction. 6. Railways may cut off supply at any point of time without assigning reasons. Under Section 43 of the Electricity Act, there is a universal supply obligation for a discount. He cannot cut it off. Melots, in this light, The appellate tribunal, my lords, based on this factual rendition, comes to a conclusion saying power supply given to a canteen, to a hospital, etc., within the railways ecosystem is not sale to a third party, and therefore those ecosystem recipients are not consumers by virtue of the definition of a Consumer and Electricity Act, which says that he must be, my lords, a rank outsider and getting power for his own consumption in the absence of a jural relationship with, my lords, the principal. And, my lords, unfortunately for them, the definition of railways under the Railways Act Section 11 includes the hospitals, canteen, etc. So it is railway taking power for railway to be consuming power. So therefore, my lords, the definition of consumer under the Electricity Act not met. My lords, third submission. And this is, my lords, the last but one, the fourth submission I'll end. Kindly see, my lords, area of supply, my lords, as defined. My lords, there are two sections. Section 14, my lords, bottom common denominator. Let us assume, my lords, Section 14 gives them the status of a distribution licensee deemed under Proviso 3. But conditions of that activity as to how, once they are a deemed distribution licensee, how should they act, in which area they can distribute electricity, is governed under Section 16. And Section 16 indicates, my lords, in every license, what is the area of supply. For example, my lords, in my license, my area of supply is, my lords, for one division itself is Bilaspur, etc., etc. So it can't be that railway says, I will put a track tomorrow in a particular area, and therefore that area becomes a deemed supply area for me. Why? Because I'm a DISCOM, my lords. Railway lines go through my DISCOM. There is an area of supply demarcated to me by the Regulatory Commission under the Electricity Act saying this is your exclusive area of supply. Because a line interdicts that area of supply, that line cannot, my lords, automatically become another distribution licensee's area of supply. That's chaos. Now, there must be some method to that madness, my lords, as to whose area of supply it is. Who determines that? Appropriate commission. Under what? Under Section 16. Are they exempt from 16? They are not exempt from 16, my lords. Even if all their arguments are on, they are not, because they admit that position. Kindly see, my lords, we are various commissions. I am, my lords, here because the Orissa Commission held in my favor. Railways went up to APTEL. Therefore, I am defending the Orissa Commission order. But in CERC held in favor of railways, saying railways is a deemed distribution licensee. But in that very order, CERC said, yes, I hold you to be a deemed distribution licensee, but the conditions of that license will now be determined by the appropriate commission under Section 16. They do not appeal that. Therefore, today they are not in appeal over that order because now it's admitted position, even assuming they say they're deemed distribution licensees, 16 prevails, area of supply must get demarcated, and that area of supply cannot intrude into my area of supply. My lords, please see, my lords, the CERC order for 1 minute, my lords. It is in, my lords, in the appeal paper book itself, 584. I'll just show, my lords, one paragraph. My lords, it's volume 2 of the paper book, my lords. Next.
You have to show the license.
My lords, please come to 584. And please see, my lords, in I'll straight away come. The order starts, my lords, at 583. But I'm, in the interest of time, troubling your lordship, straight away to 584 middle quadrant. Please see, my lords, B in 584. I'm so sorry. My lord, this. Yes, 584, my lords. Please come to middle quadrant B, my lords. The petitioner is a deemed licensee under the third proviso of Section 14 of the Electricity Act, and no separate declaration to that effect is required from the appropriate commission. This is, my lord, CERC's findings. Now, please see the next line. The petitioner, as a deemed licensee, shall be bound by the terms and conditions of license specified or to be specified by the appropriate commission under the proviso to 16 of the Act. So, even assuming, we of course contest that they are not deemed licensee, even assuming they are so, my lord, 16 comes into the play of saying what is your area of supply. Now, it can't be that entire country is their area of supply because, my lords, barring maybe 3 or 4 districts, my home district, Coorg, my lords, is a railway free zone. We have no railway lines. Therefore, barring, my lords, such pockets, their whole distribution license area is the entire country. It can't be one deemed licensee for the entire country, my lords. Because, my lords, kindly see the interoperation. Each state, my lords, makes a license condition for the DISCOMs within its state. My lords. Each state commission, my lords, makes its conditions for its licensees. Now, if there is, my lords, there is an introduction of a deemed licensee into that state, then, my lords, states in which railways have a larger network, what happens to the cross subsidy, my lords, for the bottom of the pyramid people in that state? Now, this, I'll make, please permit me to make that a constitutional submission. Each state has poor and the rich. The rich and the industries consume power and pay cross subsidy surcharge so that the poor get, my lords, subsidized power. Your lordships have held, my lords, in Chameli Singh that electricity is a fundamental right. Your lordships have still not held that railway travel is a fundamental right. Movement is a fundamental right. Now, if electricity is a fundamental right, state makes sure that it is effective because there can be cheaper power coming to me. If electricity is given to me and I'm charged 10 rupees, my lords, that fundamental right becomes ocious. Now, how is that fundamental right made effective? Because there's a cross subsidy surcharge so that the poor can pay less, the richer industry will pay more. Railways comes in the richer industry bucket. My Lord, Justice Sharma pointed out that there is public interest. People should get cheaper ticket, but not at the cost of a huge population not receiving power at their doorsteps, because the cross subsidy, which makes their tariff 1 rupee 50 paisa, when the cost of power actually is 3 rupees, my lords, is lost if railways, my lords, as the largest consumer, simply steps out of the basket and pays no cross subsidy surcharge. Now, my lords, to that, please see the last submission. Your lordship saw, my lords, this is something that, my lords, I'm placing in aid of, my lords, what Mr. Maninder Singh pointed out. Apart to, my lords, factual, one tool of interpretation when we're looking at a legislation is what was the legislative wisdom behind that statute in including a particular word. When they said appropriate government distributing electricity, they did not mean railways. Why? Because an amendment was proposed thereafter is what was shown to your lordships. Now, that was therefore as a sequitur argued before your lordships. What is the need to amend the law if the law already covers railways? But your lordships had an occasion, my lords, to look at it in Vodafone, when, my lords, the direct tax code did not tax sale of shares by a foreign resident in a foreign company. The argument was, no, the code covers it. When the matter came up, my lords, before the Supreme Court, Justice Kapadia examined the amendment to the direct tax code, which specifically brought in sale of shares by a non-resident in a foreign company also to be taxed in India. And, my lords, rendered that therefore as a tool of interpretation, that means that the law as it stands today does not cover it. Please permit me to play just one paragraph, my lords. I've requested the book, my lords, to be placed before your lordships. Please see the judgment, my lords, in Vodafone. My lords, Vodafone is 2012, 6 SEC. Please permit me to come straight away to paragraph 92, my lords. My lords, 673 in the page number, the book page, my lords. Paragraph number 92. My lords, bottom quadrant of 673. My lords, please see 92. I will, my lords, read 92 slowly and commend it to my lords, and with that, the last thing is one pleading to be shown. That's it. My lords, lastly, it may be mentioned that the Direct Taxes Code Bill of 2010 proposes to tax income from transfer of shares of a foreign company by a non-resident, wholly outside India, where at any time before 12 months of the preceding transfer, the fair market value of the assets in India owned directly or indirectly by the company represents at least 50% of the fair market value of all assets owned by the company. Thus, the DTC Bill of 2010 proposes taxation of offshore share transactions. This proposal indicates in a way that indirect transfers are not covered by the existing Section 91I of the Act. In fact, the DTC bill expressly stated that the income accruing from indirect transfer of a capital asset situated in India would be deemed to accrue in India. These proposals therefore show that in the existing Section 91I, the word indirect cannot be read on the basis of purposive interpretation. Therefore, the government distributing electricity in the third proviso of 14 is actually the government's distributing electricity when the law was made, and even today. It is not indirectly railways or tomorrow the Shipping Corporation of India or tomorrow some other entity, DMRCL. Lastly, please see, there was much argued saying that the predication was, I am buying power, I have a distribution installation under the Act. You should deem that distribution installation to mean distribution system under the Electricity Act. And I am giving power to the canteen fellow example. Therefore, I have consumers. Well, that argument before your lordships is directly in contradiction to their affidavit, my lords, in my proceedings before the Orissa Commission. Please permit me to read two lines of that affidavit, and my lords, I end. My lords, that affidavit in the Orissa Commission, your lordships will find. Well, yes. Yes. No, I have not extracted it, Malach. I am. I have references there. I have not. I'll just indicate that. I'll not read, Malach. They in para 10 indicate that we do not supply power to any consumer as is understood of any other distribution licensee. I am consuming power for my own use as railways. Those are the words that they use. And why? Because there, my lords, in Orissa, why did they say so? In Orissa Power Transmission Corporation went to the commission saying, CERC has held them to be a deemed distribution licensee. Therefore, you, the commission in Orissa, please set down the conditions of the license. To oppose condition of license, they say, Orissa, you please don't put any condition of license because I am deemed distribution licensee, correct, but I do not supply power to anybody who's a third party or a consumer. Therefore, you don't give me any other condition, which means I must be a deemed distribution licensee. I must have a separate artificial island of no conditions, and I must consume my own power for my purposes from the traction station to the railway engine and not pay cross subsidy. Respectfully, my lords, if that is done, it would actually militate, my lords, against the act is my submission, and I'm grateful, my lords.